first off, as we just mentioned, that fine could have been much higher on Meta platforms. It still was substantial, $1.3 billion. Were you trying to send a message with this fine?
So the fine could have been higher, but I don't actually think the fine is the most significant measure that we've imposed in this case. So as you summarized very clearly there, it's a case about transfers of information of EU persons from the EU to the US. And so in addition to the fine, what we've done is impose two orders. One suspends the transfers of personal data from the EU to the US, and that will take effect in 5 months' time. And then a second order imposes a cessation on processing of personal data already transferred, including cessation of storage of the data. So it's actually those two measures, I would argue, over and above the fine, that will really take effect. Because, of course, a lot of US companies that have operations in Europe routinely bulk transfer data back to the US in order to have it sub-processed there, to have it aggregated and to have their experts analyze it. And so this will have very significant effects.
Yeah, I mean, to your point, this is actually a very common practice where the data is sent back to the US. Most of the hyperscalers that these companies use are US based. We're talking about Amazon, Microsoft, and Google. So can I ask you, what solution would you like to see done? And why do this now when there's more regulation coming down the line, I believe in July, that could have also addressed this?
So this has been a long-standing issue under EU data protection law dating back to the 1995 Data Protection Directive. It's explicitly prohibited to transfer personal data of EU persons out of the EU unless it's to a third country that ensures what's called an essentially equivalent level of protection. So these issues have been running a long time, and they came into sharp relief with the Snowden disclosures back in 2013. And so really since that time, in fact, my office has been investigating these issues. There's been various pieces of litigation and legal proceedings that have happened in the intervening period, but of real significance was a judgment from the Court of Justice of the European Union, Europe's highest court, in July 2020, that struck down an agreement between the EU and the US called the Privacy Shield that underpinned transfers of personal data, but also which really spelt out that any of the mechanisms companies were routinely using, including contracts that Facebook was using, that none of those really were sufficient to compensate for deficits in US laws and practices. And in particular, what's at issue is that there's no system of redress for EU persons if there is a concern that their information has been unlawfully and disproportionately accessed by intelligence authorities in the US. So really the solution to this is some element of reform and a new agreement between the EU and the US. And there has been substantial progress made on this, as you said. You asked me, why did we move now when there has been progress made and an agreement in principle? But I suppose the point is, it still hasn't come into effect. This new agreement called the Data Privacy Framework, it's still pending. And at the time I concluded my investigation last summer, it still wasn't really on the horizon. So I have to enforce the law as it is at the time.
All right, we're talking about EU regulation, but individual countries have also been addressing this issue, specifically France and Germany, pushing for sovereign clouds. Would simply a sovereign cloud for the European Union, would that solve the majority of these issues?
Well, I think that's not really for me to say, and it's certainly not what we're seeking to push in regulating under the GDPR. I mentioned that starting point of a prohibition. So we're really enforcing the law as it is. We're not suggesting that the solution has to be that data is only processed in Europe. There are other ways in which essentially equivalent protections can be achieved. And clearly the EU and US is trying to negotiate something that will deliver that. So it's one of the solutions, but I wouldn't say it's necessarily what we're driving towards. We're enforcing the law as it is.
Okay, I want to talk to you about another big part of the whole tech landscape. Alphabet CEO, Sundar Pichai, he's set to meet with EU regulators in Brussels today, including the bloc's industry chief in charge of rules that will require companies like Alphabet to allow business access to user data generated on their platforms. So ahead of that meeting, Mr. Pichai writing in a Financial Times editorial yesterday about the importance of responsible AI development. How concerned are you about AI? What regulation is coming down the pike that you're looking at to regulate AI as well?
So in the EU, there's a very big focus on AI now. In fact, the European Union has really been a first mover in considering laws to regulate AI. And recently, the Parliament has adopted a final position in Europe on a new AI Act, and that will now go into what are called trilogue negotiations between the co-legislators in Europe. So at some point relatively soon, we will see a new law in the form of an AI Act. You referenced there also a Digital Services Act that's going to provide researchers with rights to EU personal data so that they can look at how algorithms are processing data, what the impacts and the outcomes of that are, and feed that information back into the system. So there's actually a whole suite of new regulation that's been implemented in the EU, in addition to a Digital Markets Act that will regulate gatekeepers like Google. So I think there's a lot of concern. I think there's recognition that the General Data Protection Regulation was never going to be the start and finish of regulating platforms. And now there are more specific laws looking to target more specific risks, like the risks that may arise in certain implementations of artificial intelligence.
Can I talk to you more broadly about regulation? I mean, in general, do you believe the U.S. is doing enough? It seems like the U.S. and the EU are just kind of on different pages when it comes to regulation. Would you like to see more of this regulation coming from the United States?
There's certainly a very different approach. And of course, it's long been the subject of comment that there is still no federal baseline comprehensive US privacy law. And so I think many people would like to see that. It would at least offer a filter before the kind of big platforms and services are exported out of the US to jurisdictions like the EU. Because currently, really, what we're seeing with these global platforms is, at least in the past and pre-GDPR, they were simply designed in a certain way without fundamental rights of Europeans being taken into account. And then there was retrofitting and retro-engineering to try and make them compliant with European Union laws. So I think it would be better if we had convergence in standards and in laws globally, so that at least there's a baseline before these global systems roll out.